Thank you for joining us today. I'm Fiona O'Shea, a senior shareholding disclosure lawyer at aosphere, and have the pleasure of sitting down today with Wallace DeWitt, who is counsel at Sidley Austin and an expert in financial services regulatory law. But I think most importantly to us here at aosphere, he's our outside counsel in relation to various US shareholding disclosure regimes, and is a particular guru expert in the new 13f-2 short position reporting rules. In fact, myself and Wallace did a webinar at the beginning of the year on 13f-2, but now felt it was probably the right time to do a brief recap on where we are now in respect of the legal status and reporting details of 13f-2. So I think before we delve into the detail, Wallace, let's just remind ourselves that the SEC granted us all a very last minute temporary reprieve from compliance with the new short position reporting rules back in February of this year. And this is when they delayed the compliance date for one whole year, with the first 13f-2 reports now being due on the 17th of February next year, 2026. So I think we're 4 months now down the line from that SEC statement. So let's take a look at what the current status of 13f-2 is and some of the details around those upcoming requirements. Wallace, I thought it might be helpful to first deal with the court challenge and sort of quick recap of the background of that. Obviously, 13f-2 wasn't the most well-received new piece of regulation.
You can say that, yeah.
Yeah, I think market participants, although we knew there was something on the cards for quite a long time with the statutory authority way back in Dodd-Frank, I think everyone was a little bit frustrated about needing a bit of clarity on it, which in part led to the court challenge, obviously along with the share lending rule that the National Association of Pension Funds brought. So I think the oral hearing was back in October last year. Have we had the judgment yet?
No, we have not. So to give you the timeline, and we went through this in some detail in January when we last spoke, Fiona. Yeah. The case was originally filed by the National Association of Private Fund Managers in December of 2023. Mm-hmm. It was calendared and argued in the Fifth Circuit, which covers Texas and environs, a federal circuit court, in October of last year, 2024. We haven't heard from the court since. It is extremely rare in the US for leaks to come out of courthouses, certainly federal courthouses. I can literally list on one hand occasions when I've heard of one. Okay. And so we're just in the waiting pattern for that. And as you alluded earlier, the SEC, of course, did issue its temporary exemption in February. Interestingly, if you read closely that, the statement focuses on giving members of the regulated community of investment advisors time to prepare. There is no mention of the lawsuit or the pending lawsuit in the statement put out by the SEC. I think it's an interesting omission. It certainly is present in the minds of certainly acting chairman Mark Oweda, then acting chairman, now returning to his commissioner's office at the SEC. Certainly is front of mind, I would think, of all the SEC commissioners, but it wasn't explicitly discussed. So short answer, no, we haven't heard anything as of right now.
No, and I guess in my mind, 7 months seems quite a long time for the judges to go away and sort of deliberate. And is that particularly unusual? Do you think there was some kind of waiting pattern that they were waiting to see what the SEC does in response, or?
So it's not. It certainly isn't unheard of. Okay. I can give you a sense, and this is entirely speculative, and no insider information is available to me or any of my colleagues. But what I would say is the calendar for a typical U.S. circuit court. I clerked in the District of Columbia circuit, the D.C. circuit, as we call it, as a much earlier, younger lawyer. Typically, the clerks who work for the judge will come on board in August, thereabouts, and continue on through July. There is a general preference for a case and opinion to be handed down during the time in which the clerk who was there at oral argument or who read the briefs or advised the judge is still in his or her position. So as a general statement, there are exceptions. It would be perfectly normal for a case to come down in June or July. In particularly complicated cases, certainly at the Supreme Court level or others, you do see deviations from that general rule I've just stated. Here, the only other item that occurs to me as to why this case would have taken as long, there's a few. One, the Fifth Circuit, as I mentioned, is in Dallas, Texas, is the courthouse here. There are some other, Louisiana, I think, is in the circuit, maybe Arkansas as well. As our overseas listeners will readily appreciate, those are not exactly the states that are readily associated with either administrative law or with Wall Street. So there may not be the depth. I don't want to cast aspersions underneath the judges or their clerks here, but there may not be the depth of precedent. It's not the kind of issue that arises every single day in the Fifth Circuit. That's possible. The other thing, the composition of the panel may be of interest. As I mentioned in January when we last spoke, the three-judge panel is composed of a Trump-appointed circuit court judge, an Obama-appointed circuit court judge, and a Trump-appointed federal district court judge, which is a federal trial court, a lower court, who's on loan to the circuit. So depending upon what those three judges heard or what their views are of the oral arguments or of the briefs, you could imagine a case in which maybe there's just counting noses. Maybe you have two Republicans voting for some outcome, the one Democrat voting against. Maybe the Democrat is drafting a dissent right now. Maybe the two Republicans disagree. Maybe all three judges agree, but they want to write separately and in concurring opinions. There's any number of possibilities here. And I think as I was reviewing for this meeting today, Fiona, I remember you and I had discussed our impressions of the oral argument when we last spoke in January. I think we both came away with the impression that the judges were curious. They were probing both sides of the debate. And I don't know that either one of us had any inkling of where we thought they would come down. And nothing has changed. For me, nothing has shifted since.
No, I think that's right. And so I guess if we were being kind of very hopeful, then we'd be hoping for something perhaps this month, next month, before all the clocks kind of change and kind of there's like a new kind of rota in place. So
I think that, I have talked to a few people in the market just saying, does anybody have any idea? Is there any rumor circulating? The only rumor I have heard recently was that the opinion was expected in April or May. We are clearly beyond that time frame at this point. So yes, I think if one were a betting man or inclined to speculate, the next speculation date, originally, I think I talked to you, Fiona, December 31st. We're going to do it before the Christmas holiday or just after the 2nd of January. Or again, the compliance date was 2nd of January. Okay, that fell apart. So then it was April, May. Maybe that seems like a reasonable, 6 months seems like a reasonable amount of time to decide this case. At this point, maybe July 31st is a number, but again, rank speculation on my part. It could easily be, next December. The only other point I would make is that the court is surely aware. I should think they've taken judicial notice of the status of this rule. They know that it is a mandated Dodd-Frank rule. They know that the SEC has essentially put it into abeyance for a year. And I think they can reasonably surmise the SEC did so, waiting for their decision. So I expect that they're working hard on it, and we should hear any day now. In fact, here at Sidley Austin, we have multiple lawyers who cover shareholder disclosing, myself included. We are sitting here refreshing our screens on the Fifth Circuit website all day, and we also have automatic alerts from the Fifth Circuit, and I know that the same is true of aosphere. So for your listening audience, we will, Fiona or I or some combination will absolutely be on top of this.
We'll get the breaking news when
yes,
it happens.
exactly.
And also, it's probably just useful to recap quickly on the particular point in that case that's most relevant to our audience here, because obviously there were a lot of issues that are part of that challenge, but I think the foreign securities point is the one that everyone's kind of waiting and hoping that we might get a little bit more guidance on.
Yes, and as I was preparing for this today, I looked back on our comments about this very issue in January, and I would commend to your listeners to go back and maybe listen to that portion of the talk, because I went into some excruciating, perhaps, detail.
No, very helpful detail.
but I'll try to keep it a bit briefer today. So what Fiona's alluding to here is an allegation by petitioners in their brief, and frankly by one of the commissioners voting against the rule when it was adopted, and also by many commenters on the proposed rule. The allegation that the SEC is attempting to steal a march somehow here and apply proposed rule 13f-2, final rule now, 13f-2, and form show to foreign securities listed on foreign exchanges, right? There was a pretty sharp debate about this topic in the briefs. Petitioners cited language from the final rulemaking. They cited comments made by Commissioner Peirce when she was voting against the rule as one of the Republican commissioners of the SEC. The SEC responded to the allegation that there was any intent to apply this rule extraterritorially, and I think the word that Fiona and I used was indignantly. I think it still remains a fairly good description of the SEC's response in their brief. The SEC specifically states in their brief that no, this was not intended to apply to foreign securities of foreign issuers on foreign exchanges. That's a misreading, and I know almost a willful misreading, I think they would call it, of the petitioners. There is a footnote to the SEC's passage there, however, which I noted back in January, where the SEC says, there is no reason for the court to reach the question as a statutory matter, as a matter of interpretation of Dodd-Frank, as to whether, to what extent Congress intended this to apply internationally or extraterritorially. Rather, the SEC's position is whatever the statute might have authorized, and we're not going to state, we think the court should reserve its opinion on that. The rule that we adopted does not apply in that manner. We'll see how this shakes out. This was as core as this question is to the listeners today and to the clientele of aosphere, and largely to our clients here at Sidley and elsewhere. This was not core to the National Association of Private Fund Managers. It was an argument they asserted. It is not the primary basis of their attack. And so I guess I would be somewhat dubious that the courts would resolve this case on the question of foreign securities, certainly the question of foreign securities alone. I think they're more likely to look at things like statutory authority for the rulemaking, and the various issues raised by both the petitioners and also by amicus curiae, including a brief that I myself penned, questioning the cost-benefit analysis of the SEC in promulgating the rule.
Yeah, no, that's really helpful. It's almost like, because we're focusing in on such a narrow point, but it's worth bearing in mind that actually that isn't the main kind of
It's a piece of a larger jigsaw puzzle, is the way I would describe it. The other point I would make in this connection, the SEC has now taken a position in a court filing that states what I've just described. It would be very difficult for any SEC to backtrack on such a statement, now that they've taken a public position to that effect. And it would be doubly so given the political winds in Washington, and given that the folks who dissented from the rule at its original adoption on the SEC are now in the majority of the SEC. So I think, if I had to lay bets on this, again, rank speculation on my part, but I would not expect, under the current leadership of the SEC, I would not expect a return to a maximalist understanding of the SEC's extraterritorial jurisdiction on this point. And so if that helps any of the listeners sleep better, take it to heart. But just be sure that you take it with a grain of salt, because we don't know anything yet.
It's like the direction of travel is kind of that.
The direction of travel, yes.
Expect it to sort of be going. And I suppose related to that is, I think when we spoke earlier in the year, you went through all the various different kind of options the court kind of has. And really, if I recall, none of those kind of mean that we lose 13f-2. It's kind of, it kind of gets referred back. It's the SEC kind of that we're waiting for their clarity from.
Right. Yeah. Right. So that's a very important and sort of subtle point to make within the US legal system, Fiona. The petitioners are not challenging the constitutionality of the Dodd-Frank provision that imposed 13f-2. So the Dodd-Frank mandate will survive this current action. I think we can say that with certainty, unless something wild and unexpected happens here. What the petitioners did challenge was the rulemaking the SEC adopted and the manner in which they adopted it as a matter of administrative law to effectuate that congressional mandate from Dodd-Frank. So what that means is, and to give you the full spectrum of possibilities here, the court could agree with petitioners, lock, stock, and barrel. Petitioners asked for vacatur to vacate the rulemaking and to remand it to the SEC for further proceedings. If the court were simply to vacate 13f-2 and or the share lending rule, the rule would be stricken from the books, essentially, is torn up, sent back to the SEC for further proceedings. Now, that mandate from Congress remains, and so the SEC would, at its discretion and its good time, have to reissue some kind of rulemaking consistent with both whatever the court is going to say and whatever the Congress said in Dodd-Frank. So that's one extreme of the spectrum. The other extreme would be for the court to say, we uphold the SEC lock, stock, and barrel on both of these rulemakings. There is some reason to believe this could happen. I wouldn't really, I find it difficult to prognosticate which one of these outcomes is most likely. The SEC does have some strong arguments in this behalf. Among those, unlike many Gensler rulemakings that were, Gensler being Chairman Gary Gensler, the former SEC chairman, unlike many Gensler-era rulemakings promulgated by the SEC, which did not have an explicit statutory mandate under Dodd-Frank or any other statute, we do have a statutory mandate here. And so courts, generally speaking, courts, whether they're composed of Republican, Democrat, or independent judges, generally will pay attention to whether Congress has mandated the rulemaking and will generally view that with a degree of deference. Certainly where there's no challenge of the statute, they will do so. So there is an argument for 13f-2. Now, the details of 13f-2, whether they exceed what Congress asked for or demanded, whether it was adopted in the proper way, dotting all the I's and crossing all the T's, that's for the judges to decide. But you could imagine the opposite, where the SEC wins, the petitioners are told to send packing, and the rule remains as substantially as originally adopted. In that case, I would expect the SEC will immediately start thinking about what sort of guidance do we need to do and how do we actually implement this rule by the end of the temporary exemption, which I think you mentioned was February 17th. So the January filing period would be of next year would be due February 17th of next year if the SEC were upheld. In between those two extremes are split tickets. You could have the 13f-2 upheld, the share lending remanded. You could have the opposite of that. You could have I don't know specifically what provisions might. I don't know where this might occur, but you could have a court that strikes particular provisions of a rulemaking, or said that particular features of it are not permissible, but the others are. Courts will generally try to minimize the impact of their opinions and do the minimum necessary in order to effectuate their opinion. So anything in between could happen as well. My gut tells me that there were some real problems here with the way this was adopted by the SEC, but it's impossible for anyone to say what the judges will do.
It's still a wait and see, isn't it? I think.
Wait and see.
Yeah. So Wallace, I think you were kind of mentioning there potentially, what the SEC might do, kind of in response either to the court judgment. So it's probably, if we move on to that, I suppose we had the announcement in February extending the compliance date. I don't think we've had anything else on 13f-2 at all yet from the SEC, have we? No, that's right.
Nothing public to my knowledge,
yeah.
And I don't know. I can't speak to what's been done privately. I would surprise me if the commissioners were not hearing from registrants and private companies on the subject in meetings. That said, I think the general tone in the United States is wait and see, given the state of the case. So I don't know that a lot of lobbying shops are spending a lot of client dollars approaching the SEC to debate the future contours of 13f-2. I may be wrong, but given the state of affairs and the lack of knowledge of whether this rule is actually going to come into effect, I think people are just in a wait and see mode, as you suggest.
Well, yeah.
Looking at, so as for what the SEC may do in the future, I think it obviously depends heavily on what the court instructs. If the court were to wipe out vacate one or more of these rules, particularly in the case of 13f-2, which is mandated by the statute, the SEC would commence rulemaking procedures internally that would involve going to the various divisions of the SEC, investment management, trading and markets, et cetera, to get the rulemaking team back together and start working on a rulemaking. That is a process that takes a while. I don't know whether they've started that process. That would be secret, from the public anyway. But that would be one. I can't imagine that process ending without a significant lead time of a year or more. And it would be done subject to notice and comment rulemaking. The new chairman of the SEC, Chairman Paul Atkins, has specifically faulted his predecessors for the relatively brief time of public comment available for all sorts of different rules, this one included, where they were only given a month or something, it's more common to have 3 to 6 months, depending upon how complicated the rulemaking is. So there's that element on one side. The other side, if the court were to uphold the SEC wholesale, that date of February 17th would be looming. We are now into June. Let's say that we hear sometime in June or July. That would leave about 5 or 6 months for parties to get ready. I think that to the extent that parties have taken themselves out of high gear in preparation for this, pending the conclusion of the lawsuit, I think it is time to start thinking about broadly, what are we going to do to get ready if we need to get ready? That's not to say that everybody should scramble around starting to comply now, but it is worth 6 months out thinking, do we have the personnel in place? Do we know the answers to the questions that we have? And do we have further questions? On the question of further questions, or in clarity, it is common for any SEC rulemaking, certainly for a new and rather searching disclosure regime, it's pretty common for there to be unanswered questions that weren't raised in the proposed rule or weren't answered in the final rule, that sort of thing. Very normal. I think that you will find, I think what we're seeing in other areas of the law is that the current SEC is very inclined to give guidance to the market. And to the extent that listeners on this call are in direct talks with the SEC themselves or through their lawyers or through the trade groups in which they participate, this would be a good time to start pulling together what questions you might have about the rulemaking and then kick it into high gear again. If you hear, from Fiona or aosphere that the SEC has been upheld, then that's the time to really start going.
I think that's really helpful actually, because it's what you mentioned earlier when they extended it. I think part of that statement did say we're going to engage with market participants to clarify the issues that like people are having problems with. So if it's upheld, the court case, then that's the time for us to engage with the SEC to clarify those kind of implementation questions.
I'll underline that point. If you look at the February statement of the SEC, again, they don't talk about the lawsuit. They don't speculate as to that. And they have talked about other rule challenges. They didn't talk about this one. But they did really lean into the question of, if you have problems with it, regulated entities, if you have questions or concerns, they do want to hear about those. They do want to work through them. So I think you will find the SEC to be in a mindset of a desire to get this rule right, to get valuable data from it, to inform the SEC and to inform the markets, but also do so in a way that's perhaps not as burdensome as it might otherwise have been. So this is a good time to start thinking about your outreach to the SEC, to the individual commissioners' offices, or even to the staff offices that promulgated the rule. I think to the extent you have those connections and relationships, it might be time to think about are we going to take off the month of August, our traditional vacation holidays, to focus on getting this done? What I would emphasize to everyone is don't get caught flat-footed and don't put too much hope in the courts. You should trust but verify, as Reagan said to Gorbachev. You should be sure to be ready and on the balls of your feet if you need to go, because 4 or 5 months from now, it'll be January.
It'll go quickly.
You're gonna be, that'll pass quickly.
Yeah. And sorry, and I guess sort of the best scenario timing would be, kind of we might be betting that the court judgment comes out this month, next month, and then that kind of kickstarts almost hopefully the process. If 13f-2 stands, that the SEC will kind of gear up and be engaging and clarifying sort of our questions that we have outstanding. Yeah,
I would expect so. And I guess the ultimate question is whether the SEC would be of a mind to put out an FAQ document or some kind of formal, staff statement. It's hard to say. I think they will be giving individual guidance to people who call in. The FAQs tend to be pulled together, just as the name says, they're frequently asked questions. Yeah. So if there are questions that are frequently posed, like, does this apply to foreign securities traded in foreign markets? It wouldn't surprise me if the SEC came out with some definitive statement on that question, if that's something they're hearing from a lot. But call your congressman, I mean, in a metaphorical sense. It is worth putting these thoughts into the SEC staffs and political leadership's minds, because I think as Chairman Atkins says, there's a, quote, new day at the SEC, and there is a desire to get these rules right in ways that serve the markets.
Yeah, I think that's really helpful, Wallace. So I think, just to wrap up, I think it was really useful to know kind of that timing and almost useful to know that we're still waiting on the court judgment. There hasn't been any further updates from the SEC either. aosphere will continue to do what we always do, along with Wallace at Sidley's, to monitor this daily for everybody. And actually, what we plan to do is we're going to follow up, aren't we, Wallace, with another live webinar. I think as soon as the court judgment is issued, hopefully just within a few days, so it's kind of nice and current. And then we'll do another second follow-up when hopefully something more clearer guidance, FAQs, whatever statements might come out of the SEC as well. Both of those webinars we plan to have will have a live Q&A element to it, so we can all get on top and across these compliance issues as quickly as possible. So do please look out for those upcoming webinars of us. And thank you all for listening today on our 13f-2 recap. Thank you, Wallace.
And thank you, Fiona.